Hi, Chungming. Um, I forgot your voice wasn't working.
Hello.
Hi, Jenna.
Hi, is my audio okay? Because it's through my computer.
Yeah, I can hear you.
Okay, good. Thank you. And then maybe before we start admitting people, maybe let me test that I can share the presentation. Sure.
Yeah, I I think people are just muted.
Oh, they're here and muted. Oh, but there's only your internal team, right? Nobody outside of this yet, right?
Sure.
Oh, I actually can't tell. Hold on. And this. Okay, I think. Should be able to see my screen, right? Or the PowerPoint, I mean?
Yeah.
Okay, cool. And then, because the only participants I can see are ISSC staff members. Are there others on? Can we tell?
Yes, we have we have 14 participants.
Oh, okay. Wonderful.
It sort of didn't open a waiting room. So
Oh,
bear with us, everyone. We're just waiting for a few more people to join, and then we'll get started with the presentation. Okay. Well, if everyone can hear okay, I'm Eva with ISSC, or International Students and Scholars Center. Thank you for joining us for Immigration 101, or H1B, what happens after I graduate. So we also call it Beyond OPT. So we all know F1 is eligible for OPT, sometimes STEM. We'll go over H1B. I'd like to introduce Jenna Decker-Shue. She's an attorney with the Fragaman Law Firm, who is a nationwide law firm, but they also contract with ASU. So they help with when ASU is hiring H1B and other hiring on other visas, we turn to Jenna and her team for assistance. So she's well-versed in all things H1B and STEM and permanent residence. So Jenna, I'll just turn it over to you.
yeah, thank you so much. So I think we will have time for questions at the end. I believe the ISSC team is checking for questions as they come in. If you want to put them throughout the presentation, that's fine. We will focus a big part of today on H1B and in particular the lottery, but I do want to go over foundational concepts just to kind of give everyone a big picture of what the immigration landscape looks like as a student once you graduate. So as Eva mentioned, I just practice business immigration primarily. We do some family-based stuff. We'll touch on that, but what my firm does most of the time is represent the employer side. So as you're looking for positions, I kind of have insight. I work with about 40 different companies. So I can give you some background on kind of the things they look for and the typical visas that they hire folks into. So we will go over just some foundational concepts first, and then we will talk about the different non-immigrant visas, as well as touch briefly on what it looks like if you want to become a permanent resident. So for those foundational concepts. So for those of you going through the immigration life cycle, you might be here already on an F1 or J1. Those are all types of non-immigrant work visas or work authorization here. We usually keep that going as permanent residency. The initial steps themselves don't provide status or work authorization. So you want to keep those going, which is why those circles kind of look like they're overlapping until you finally get the goal of the green card. It's most folks' goal to be here and to stay here long term. You need that green card to remain in the US permanently. For that middle step, waiting for an immigrant visa to become available, it really differs in terms of timeline, depending on your country of birth, not citizenship, and the type of immigrant visa application that you or your employer may be filing on your behalf. So if you are not Chinese or Indian born, that wait time is sometimes no wait at all, and sometimes it could be maybe 3 years. Fortunately for our Chinese and Indian born applicants, it's a long wait time, anywhere from 2 years right now is the fastest, all the way up to 12 or more years, just depending. A couple of things we think it's really important that you keep in mind throughout your immigration life cycle is you really need to understand the different documents that come with immigration and ensure you are never out of status. So there are different things like a visa, a petition, an I-94, and they all mean a little bit different things, and there are different consequences if any of them expire. So the visa is for those who are not Canadian. It's a stamp in your passport that allows you entry to the US. So you have to get that right now at a consulate outside of the US. There is no way to get visas right now from within the US. But the good thing is if you're in the US and that visa expires, that's fine. You do not have to have a valid visa to remain in the US. You only need it to return or enter the US. You do need to make sure, though, that you have a valid petition and I-94. So for some status, the I-94 is duration of status. It just depends on the petition, but for others, that I-94 is critical. So for folks who maybe have an H-1B or are hoping to get an H-1B, it is important that you look at your I-94 online upon each entry. And then other visa types have different requirements. So like for those of you F1, when you graduate, really keep track of your periods of employment to ensure that you aren't going over any of your unemployment time that make you potentially ineligible for visas down the road. These non-immigrant visas, often what they mean is you don't intend to remain in the US permanently. Most of the categories are very strict in that the government thinks you must have an unabandoned residence abroad that you intend to return to after your temporary stay in the US. So that is F1s, J1s, your B1, B2 visitors, and maybe treaty categories like TN or E3. If you are in one of those strict non-immigrant intent categories, it can make transitioning to a green card a little bit difficult because when you're filing for a green card, you are declaring your intent to remain in the US. So if you get far enough along in permanent residency, you might not be able to exit and return to the US if you're in a status like F1. So that is one really good thing about the H-1B is that it is dual intent, meaning you can have permanent residency going and still be on the H-1B visa. So some of the employers that we work with do require folks to have H-1B first because of that intent issue. But most of our employers will actually start permanent residency even if you are in a different category like F1 because it does take quite a while to get to permanent residency. And that gives you a couple of tries at the H-1B lottery and not delay your permanent residency. So if you get with an employer and they have a program of starting permanent residency quickly or right away upon hire or shortly after hire, just keep in mind when you get to filing the I-140, the immigrant intent visa, you might have travel restrictions that you should consider before you proceed. Another very high level just thing to keep in mind, there are some decisions that you could make that might impact your immigration in the future. So there are not very many exceptions if there are any criminal issues with immigration. If you get a DUI or have any sort of drug use, even if it's legal in the state where you are, marijuana is not legal under federal law, so that can cause some serious immigration consequences. With something like a DUI, usually that might not affect your immigration down the road as long as there aren't other extenuating factors, but it does cause your visa, if you have one, to be automatically invalidated so that if you need to leave the US, you'd have to get a new visa and you would very likely have to go to like a doctor's visit as part of your visa application to show that you don't drink too much. And that can cause delays to your visa processing. So just keep these things in mind, make smart decisions. If you have to, you want to go out, make sure you are smart and get an Uber or a Lyft on the way home so that you don't have any of these issues that could impact immigration. Okay. So now that we've kind of set the stage with some helpful background information, we'll go a bit more in depth into the non-immigrant visa categories and ways that you can continue to remain in the US and work in the US after you graduate. So we also often say that immigration is an alphabet soup because our visa types have different letters of the alphabet. All the way A through V. We won't go through all of them. I kind of bolded the ones that I see most often in my practice and ones that you may look at post-graduation when you're looking to work with a US employer. So F1 OPT, we of course have the experts on the line here with your International Student Services Office, but just from my perspective, employers are looking for folks that do have that OPT available and the opportunity to especially apply for the STEM extension. There are more categories now than ever before. So that is good if you qualify and you're studying in a field that allows for the STEM extensions. But it's really important during this time to keep your DSOs up to date on any changes in terms of employment, location, that sort of thing. You need to communicate with a lot of people as an F1 student. You need to communicate with the DSO, with your school, with your manager, with your company's HR, just so that everybody is aware and that you're doing things so as to not cause any immigration impact. If you're eligible for the STEM extension of your OPT status, your managers at the company will play a more active role in providing a training plan and evaluating your performance during that time. And then it's just important for you and your employers to know that the compensation has to be commensurate with US employees, and you could have the government come to check on you in your program and make sure that you and the company are complying with the terms of the OPT program. Couple of other things to keep in mind with the Fs. Your employer has obligations, which you should make them aware, but they should be aware as well. The training plan, I think, is pretty clear with employers on what they need to do. They need to notify your school if you are terminated before the end of your OPT period. And if there are any major changes to your position or a training plan, they need to file a new training plan with the school. You all as students must also report any terminations, job changes, changes to personal information or employment information, and ensure that your CVIS record is up to date and accurate. So keep those things in mind. Reach out to your DSO or ISSC if you have any questions about your obligations as an F1 individual using OPT. Okay, so now we'll get into the more meaty H-1B. I think this is really the bulk of what we are hoping to share with you all today. So H-1B is the gold standard in my mind of work authorization and non-immigrant visas. It is for positions that are considered to be specialty occupation. That means that a bachelor's degree or equivalent or higher must be required as part of the position. So that's the first thing. And it really needs to be standard across the field that that type of degree is required. So even if your employer requires it, but that's not the norm, USCIS might question an H-1B filing. The other thing to keep in mind is that your degree really does need to be related to the position and part of the normal requirements of that position. So if you are applying, for an accounting position with an art degree, that's not going to work out so well when USCIS looks at the petition. The H-1B has a 6-year maximum stay. You get approvals in 3-year increments, but the great thing about it is that it can be extended beyond those 6 years if you are pursuing permanent residency and you get far enough along in the process. So usually by about 3 years into your H-1B, if you have not found an employer that is sponsoring you for permanent residency, you should really start to consider that in your career and when making decisions about potentially changing positions, because you need to get either an I-140 filed or a perm filed at year 5 of your 6 years in H-1B. Or you need to have that I-140 approved before you reach the 6th year of H-1B. So if you do that, you can extend until your priority date becomes current and you're able to move forward with the permanent residency process. The downside, so if you think, okay, H-1B is so great, that sounds awesome, why doesn't everyone just get H-1B? Well, unfortunately, it is a lottery. There is a statutory number of petitions available each fiscal year. The fiscal year starts October 1st. So there is only 65,000 H-1B petitions available. Some of those are set aside specifically for citizens of Chile and Singapore. And there is an additional 20,000 if you have a master's degree or higher from a US institution. So only 85,000 total available each year. The demand is much higher. We estimate, based on last year and prior years, demand is probably between 400 to 500,000 people looking for an H-1B each year. Now, keep in mind, excuse me, any employer can file for an H-1B, even if the person that they are filing for isn't currently in the US. So you're dealing with not only, US-based positions or employers seeking out the H-1B, but also those outside of the US. So that is one kind of negative and why we see higher demand. Another reason why we saw some increased demand over the last 2 years is the process for the lottery right now includes a registration. The registration has been pretty cheap lately, only $10 to enter someone in the lottery. That will be changing this year, and I believe it's going up to $250. So perhaps demand will decrease slightly this year, but that's still not a very high bar to entry. And so some employers, just kind of include anybody because they want better chances at the lottery. In the past, we've also seen some fraud from individuals in applying for the lottery. So before last year, an individual could have 10 different employers enter their name in the lottery 10 times, and they thought that would increase their chances. So we were seeing people, submit multiple 10, 20 registrations. And so one year there was almost 800,000 registrations submitted. Now, this wasn't 800,000 people. Again, this is people submitting more than one registration. And so that significantly decreased everyone's chances of success. So last year, USCIS saw that as an issue and implemented a new system where individuals are selected based on their passport. So even if multiple employers register them in the lottery, they only have one chance at being selected. So last year, the percentage chance of success for the H-1B lottery was about 30%. So we had some of our employers sit there. Some of our employers had, 40 or 50%, some only 20%, but on average across the US, the selection rate was about 30% chance of success. So again, just to kind of talk through the timeline with electronic registration. So how this works is USCIS will typically open up registration for the lottery in around February of each year. They give us a 2-week period to register individuals, and then they close the registration system. And then about a week or two after that, they make their selections. So selections usually come mid to end of March. Then we are able to file H-1B petitions for anyone selected between April and June. And those petitions are effective October 1st. So for a lot of our employers, even if you haven't graduated yet, but if they've made an offer and you've accepted to start in May, our employers will include individuals in the lottery. So you don't have to be working for a company for them to enter you in the lottery. And we allow people to be added to the lottery from our employers all the way up until about March 1st. So keep that in mind as well as you're looking for positions, accepting offers, that sort of thing. Ask if the employer would include you in the lottery, even if you might not start until graduation. Now, in the end, let's say you have two offers and you accept one of those and they put you in the lottery. If you decide to go for another employer, if they didn't enter you in the lottery, that could be harmful if you wind up being selected. You do need to work for the employer that submitted a registration that you were selected under for at least 2 months, so from October to December, in order to be considered counted against the cap, the H-1B lottery cap. So keep that in mind as well as you are making decisions about which positions to accept. So there are some employers and reasons why you can be an H-1B and not have to go in the lottery. There are some instances in which you are not counted against the cap. So if you get an H once in the lottery and you're selected, and then you need to do an extension or amendment or change employers, you don't have to go through the lottery process every time. Once you're selected in the lottery, you get to kind of keep that approval and it stays with you as you transition between roles and employers. If you don't use all of your 6 years of your H-1B lottery, you can continue to use that without having to be subject to the cap. And then also there are institutions that are nonprofit, research, government, higher education institutions like ASU that are also not subject to the H-1B lottery. So you can get an H-1B and be employed for those types of institutions without going through the lottery. The important thing to remember, though, is if you do get a job and are in H-1B not subject to the lottery, if you wanted to then switch to a different employer that would be subject to the lottery, some sort of private institution, then you can't do that. You can only switch if you've been counted against the cap. You could go to any employer, or if you work for like a nonprofit or a university, then you could only switch with a similar institution. So keep that in mind as well, that if you don't go through the lottery process, it does make things a little bit different if you have a need to change employers. And then about the lottery, the last couple of years, we sometimes see a second round of selections. So what happens is you have 85,000 numbers available. The government usually chooses more numbers than that because they know not everyone will wind up filing petitions. So they maybe select 100,000 or 125,000 people for the lottery, and those people have until June 30th to file. Sometimes for whatever reason, they see high numbers of people not file applications. So maybe it was those abroad organizations, they submitted for a bunch of people and they didn't actually need that many people to come, so they don't file all of their selected cases. Or maybe someone, filed, but then for whatever reason, they decide they need to move back to their home country, so they don't pursue an H-1B filing with the employer that registered them in the lottery. So because of that, we sometimes do see second selections. When that happens, that usually occurs in about August of each year, but numbers are very small. So it's, maybe an additional 2 to 3% of people, just a handful more of cases selected. But it is something that everyone hopes for. And then USCIS does ultimately let us know once they have selected everybody that they need to select, and that the lottery for that year is over. So this year there was a second selection. The filing window closed at the end of October, so we know now that it's done and we don't anticipate any more selections for this year. So a couple of notes or questions on the H-1B. So you might want to know, who can I work for when I have an H-1B? So you really need to be working for the employer that sponsored you. You can potentially do concurrent H-1Bs if you have two employers sponsoring you, but that can get a little bit tricky. In terms of any sort of entrepreneurial work, if you want to, run your own business or that sort of thing, we do not recommend that when you are in H-1B. Any sort of active investments or jobs where you are taking a role or responsibilities, you should not be doing that when you're in H-1B. Now, if you just are, maybe you're investing money, investing stocks, you put your money somewhere and you have someone who moves around, the money to help you grow your investment portfolio or something like that, that's fine. But just keep in mind, like running your own business or things like that is not recommended on the H-1B. H-1Bs can be part-time. You can change employers, as I mentioned. The new employer would have to file a new H-1B. The good thing about change of employer applications is you can actually start working for the new employer when the petition is filed. You do not have to wait. If it's an H to H transfer, you don't have to wait for it to be approved. On the flip side, let's say you were going from F1 to H-1B, that H-1B has to be approved and effective before you can start working using the H-1B. Similarly, if you go from, F1 to O1, O1 would have to be approved before you can start working. So keep that in mind. And then also just keep in mind that you have that max of 6 years in H-1B. So if your employer has a rule about not starting permanent residency until you've worked there for 1 year or 2 years, whatever that might be, keep that in mind. If you're waiting that long, you then might have to stay put for a while to ensure that you get far enough along in permanent residency so you can continue to extend beyond the 6-year maximum. If you get a promotion or a job change while you're on an H-1B, you might be required, your employer might be required to file an amendment to the petition with USCIS. Also keep in mind for H-1Bs, they are very sensitive to locations. So if you are, maybe working remotely, if your employer might allow that, and you're living in Phoenix, but you decide, hey, you know what, I want to move to the Bay Area in California. I work remote, it's no big deal, I'm just going to move. It might be a big deal, and actually it would be a violation of status if you were to move before an amendment is filed. So again, communicate to your employer, to their immigration counsel, so that everyone can be on the same page with any actions needed so that you don't have any violations of your immigration status. And then if the rules are very different, it should still be fine, but just keeping in mind that regardless the role, it still needs to be that specialty occupation, and your degree still needs to be related to the position. If you are on H-1B and you lose your job, maybe layoffs or you quit, you do have a 60-day grace period. That grace period in terms of when it starts is a little gray area with immigration. They clarified to say the 60-day grace period starts when employment ends, which is usually the last day paid. So you can rely on the last paycheck. Some employers, if there are layoffs, they will, pay you an extra month or two as part of a severance or something like that. So you could count those 2 months. The safest thing to do is start the 60-day clock when you actually stop working. So that's up to you. And as long as you understand the potential risk, you can go by either date, but I prefer to go by the date of the last day worked. And you just have to have a new employer file a new H-1B petition for you before the 60-day grace period is up. And then just keep in mind, if you are terminated, not for cause, but like a layoff or an action, the employer does have to offer you a return cost of transportation to get back home, just for yourself, not for your dependents or for your belongings, just transportation for you to return to your home country. Okay, we're sticking on these H's for a minute. So another thing we get asked about a lot is cap gap. So you do get extended work authorization if you are selected in the lottery. So let's say your F1 STEM OPT is going to expire June 1st, but you find out on March 30th that you're selected in the lottery. You get to continue working until the H is effective October 1st, so long as that H-1B petition is filed timely. So keep that in mind. If you have an OPT that is eligible for cap gap, but you could do a STEM extension, we do recommend you do that, even though you might get the benefit of cap gap, because USCIS can do some funny things sometimes. H's that we feel are very strong, that meet specialty occupation, you could get an RFE or even a denial of that case. And while an employer might try to fight that with USCIS, it would put you in a pretty bad position if that were to be denied. So we always say it's good to have backups in immigration. So if you can keep an F1 EAD going, we would recommend you do that if you're able to. And then just keep in mind international travel as well if you are selected for the H-1B lottery. It is a change of status application most of the time, and if you travel while a change of status application is pending, it can be denied or approved as what we call a consular approval, meaning you have to travel to activate it. So just keep in mind as you plan any travel, if you're looking to be included in the lottery, if you want to travel between April and let's say September, you should communicate those plans. My recommendation would be to try to travel and come back by April or May, if at all possible, and then file a lottery petition after that time. You can be included in registration, no problem. It's just if you're selected and you need to file something, you need to keep that in mind. So just communicate. And then also, if you're going to travel, talk to your DSO, make sure your CVIS record is still looking good if you potentially need to travel before the H is effective October 1st. You just want to make sure your CVIS record hasn't been closed out inadvertently or something like that, and we don't want to face any issues when you try to come back into the US. So, there are, what do you need to think about if you really want that H-1B? First of all, you have to find a job. You have to find an employer that will sponsor you in the lottery. The employer must pay the H-1B fees. You cannot offer to pay that for an employer, and they have to pay you at or above the prevailing wage. The prevailing wage was meant to protect US workers so that foreign workers weren't coming in and being paid less and then taking their jobs. Sometimes it actually now makes it so that foreign workers are paid more than US workers, because the prevailing wage sometimes doesn't match the reality of what is offered at a location for a specific industry. But so your employer, that's something they would have to consider if they want to sponsor someone for H-1B. It has to meet the prevailing wage. They have to agree to include you in the lottery by the March deadline for registration. Otherwise, you might lose that opportunity and have to wait a whole year to be included in the next lottery. Then you have to beat the odds, get that 30% chance of selection and win the lottery. And then finally have USCIS agree with your employer that it is a specialty occupation and that you do qualify for the H-1B. So lots of steps, not the easiest of tasks, but the H-1B is a great visa and well worth it if you can check all those boxes. So what we'll go into next, kind of moving away from H-1B now, is what if you can't get an H-1B? What do employers do with individuals who come in as F1s and work with them for 3 years on their OPT? What kind of things can you look at? So we'll talk a little bit about L1s, J1s, the treaty visas, O1s, and continue your education potentially through another F1 program. So J1 exchange visitor is a potential option. There are a lot of categories available for a J. You can continue on, being an intern, you can be a research scholar, you can further your education on a J, but it's really important to know if you are looking at J1 programs, you might be subject to what's called the 2-year home residency requirement, where you have to go back to your home country for 2 years after you complete the J program, or try to get a waiver. And sometimes those waivers can be pretty challenging to get. If you are from a country that's on the skills list or you receive government funding, you're going to be subject to the 2-year home residency requirement. So while the J1 is an option, it wouldn't be my first recommendation to you all if you are looking for ways to stay in the US, but there are some good programs out there. And if you really aren't that interested in permanent residency and you just have a specific goal of what you want to accomplish in the US over a couple of years, then it might be something to consider. The one that we look at quite often for our employers is the O1. So the O1 is for those with extraordinary ability, maybe in science, business, athletics, arts, education. You have to demonstrate that you have national or international acclaim and you are going to continue your work in this area of extraordinary ability. It does need to have an employer and a job tied to it, but this is one where you could file yourself and pay for fees yourself if needed. If you have had a J in the past and you are perhaps subject to that 2-year home residency requirement, you can obtain an O1 visa outside of the US. It's good for 3 years initially, but it can be renewed indefinitely in 1-year increments. Keep in mind though, when you get to permanent residency, it is not dual intent like H-1B, so there can be some travel restrictions while you're waiting for a green card. Now you might think, hey, this sounds pretty great. Why don't people do this more? Well, it is a pretty high standard to get approved, so that can be a little bit difficult. So the kind of things we're looking for are prizes, memberships in different associations, published materials, citations, original works, participations in panels where you're judging the work of others, having a job offer with a very high salary, and then looking at your role to see if it is critical for the organization that has a distinguished reputation. So these are very subjective criteria. So the officers that are adjudicating these cases have a lot of discretion to approve or deny, which is quite frustrating because you might have a couple of people with very similar backgrounds get very different results. So that can make it challenging. And this is one where over time we see trends, and I think it's part of what the different government offices have their officers focus on. So sometimes I think the officers are given the directive to perhaps be a little more lenient and lower their criteria for who they might approve. And other times they are told to really make sure only the best of the best are getting the O1s. And therefore we start to see denials increase. So usually with O1s, we're seeing PhDs with 100 or more citations, some patents, and again, a lot of that membership and review work on a person's resume. So not everyone qualifies, but it is something we look at for people who are not selected in the H-1B lottery. We also, see quite often the TN category come about. For these, you must be citizens of Mexico or Canada. It's only available to certain fields. So, engineers are there. There's a bunch of scientist categories. There is no manager category for TN. So that's important to keep in mind. And they do have really specific requirements of who qualifies. So the position must qualify, but also the individual must have the required background. So sometimes it's just an educational background. Other times it's education plus experience. Sometimes it's, working under the supervision of someone who meets a specific background. So something to consider if you happen to be a Mexican or Canadian citizen. And then I just want to touch on the L1s. I don't have a specific slide for them, but not all companies have what's called an L1 program. These are typically your companies that have a really big overseas presence in multiple countries. And when this is looked at as a possibility, an individual must go live and work for that company outside of the US for 1 year in a position that is managerial or requires specialized knowledge, and then come back to the US to work for that same company in a similar role in the US. So it can be kind of cool. It gives you exposure to other areas of the company if you really like it. It gives you an opportunity to live in a different place for a year. But for others, if you have a family here, if you have young children, it can be disruptive to leave for a year and then come back. So that's something to keep in mind, but it is an opportunity that a lot of the clients that we work with do look at for their employees. Okay, so kind of moving out now of the non-immigrant visa world and that sort of immediate post-graduation work authorization to touch a little bit on permanent residency and immigrant visas. So there are a couple of ways to get green cards. We, like I said, focus primarily on the work or the employer-sponsored green card categories. There are also family-based permanent residency categories. There is a diversity visa lottery for permanent residency, and there is asylum for those who have certain conditions that lead them to be fearful of returning or living in their home country. So I'll just touch briefly on some family-based that we see more often. So if you have an immediate relative that is a US citizen, so example, if you marry a US citizen, you can qualify for pretty quick permanent residency. And then if there are minor children or parents of US citizens, they also qualify as immediate relatives and have no wait time for becoming permanent residents. Other family members do qualify, but there can sometimes be a wait. So spouses of permanent residents, older children of US citizens that are married, those are all categories, but they have a longer wait time. Previously, if you married someone who was a permanent resident, there was no wait. But right now, because of demand and backlog and processing times, it is about a 2-year wait if you were to marry a permanent resident for you to also be able to file for the green card. So those are just things to keep in mind. Family-based is an option. Again, for our employers, if you marry a US citizen, they may be willing to support you, pay for that cost if it can get you to a green card faster. So just keep your employer and their immigration counsel updated if you have any of those big life opportunities. The common categories that we see with our employers for permanent residency are EB1, EB2, EB3. So EB stands for employment-based, right? So the first preference category is usually the one that is the fastest because it is a very high standard. So not a lot of people qualify, and thus not a lot of numbers are being used in that category. So like the H-1B, the different preference categories do have numerical limitations, but in addition, they base the limitations on someone's country of birth. So the H-1B does not matter what country you're born in. There's only the 85,000 numbers available, and that's it. But for the permanent residency categories, there are numbers available that are based on the category and your place of birth. So EB1 is extraordinary ability or outstanding researchers. EB2 are those with advanced degrees or exceptional ability, or those whose work is in the national interest and they can get a waiver. And then EB3 is for the professional, but not an advanced degree, skilled or unskilled workers. So we'll talk a bit about EB2 and EB3 mostly here in the next slide. So typically for permanent residency, it is a 3-step process. You start with the PERM labor certification. This is where it is a test of the US market, looking for any US workers that are minimally qualified and able to do the work. It's very specific in what steps are required. So it has a great chance of success, but it does take a while. So even just to get the PERM filed takes about 9 to 12 months. And then for a PERM to get certified right now is taking around 15 months. Unfortunately, the Department of Labor and this PERM program, it doesn't have any fee to it. So there's no funding to hire more workers or make things go faster. So it tends to be put kind of on the lower priority list, and thus we can see it take a while to move forward to completion. But after you finish that step and there's no US workers and you get that certification, you get to move to step 2, which is the I-140 immigrant visa. So filing this I-140 is when you actually are declaring your immigrant intent. It is what secures your place in line, establishes or secures in your priority date. And then this is when you would start to wait for the preference category and country of birth to see when you're able to file the 3rd step, which is the I-485 adjustment of status. Most people do this last step as adjustment of status here in the US, but you can also do the last step at a consulate if you happen to be outside of the US. Sometimes in this last step, interviews in person are required. For employment-based, we typically do not see interviews, although they can come up. So we'll have to see over these next 4 years if interviews come back. But you have to do biometrics, you have to get a medical exam done. And if you have any dependents that you're married or have minor children, they would also be able to come into this last step if you're doing the employment-based categories. Now, sometimes you can skip step 1, the test of the labor market, and go straight to filing the I-140, which can help speed up processing times, but all of these categories listed here don't have that clear checklist like PERM does. So the chances of success can vary as the officers have a lot of discretion. So if you don't have a super strong background, going through PERM and getting that priority date established to ensure you have continued work authorization might be best, and then look at improving your profile or attempting other filings. So EB1B is for outstanding researchers. That must be employer sponsored. EB1A is for those with extraordinary ability. That can be self-petitioned. So if you feel like your background is really strong and you want to go and try to do that on your own without an employer, you can. EB1C is for multinational managers. So if you were a manager for a company for a year outside the US and then you're coming to be a manager for that same company in the US, you could qualify as a multinational manager. And then there is one EB2 category, this national interest waiver, that gets to skip the PERM process, and it can also be self-petitioned, meaning you can file this on your own without the support of an employer if you would like to. So it's important to keep those in mind. And if you have any questions to your employer, or you want to try to file something on your own, you can always talk to an immigration professional to see what your chances of success in these different categories might be. So just these slides have a lot of information. Both of these EB1A and EB1B categories are very similar to the O1, where you really have to show how extraordinary and exceptional you are. So again, these profiles are typically people with PhDs, a lot of citations, patents, memberships in associations, original works, that sort of thing. So this is the EB1B, which again must be employer sponsored. And then the EB1A, which can be self-petitioned, but the EB1A is usually a little bit harder to get approved than EB1B. And then finally, to end, just a couple of things about a national interest waiver. It's, again, those with advanced degrees, exceptional ability. The position must be in an area of national interest. It has to be a balancing test, a totality of your background and the position in order for USCIS to approve this case, these types of cases. I will say this category fluctuates the most in terms of approvals and denials. And it's pretty amazing that, you know, if you try to get it done faster with something like premium processing, that can significantly decrease your chances of success, which shouldn't make a difference because your profile is the same regardless. But it's important to keep in mind. So this is one where going into the new administration, it might not be as easy to get approved. So if you're considering it post-graduation in May, you know, maybe test the waters. We'll be seeing come, you know, February, March, April, what changes might be happening. And I know at our firm, and I'm sure at other firms as well, we are always tracking data to see what types of cases are getting approved, RFE'd, requests for evidence from the government, or denied, so that we can give the best guidance and recommendation to our employers and the individuals in terms of the best path to permanent residency. So I know we have the whole time for an hour and a half, just in case there were a lot of questions, but that is the end of my presentation. So I don't know, Eva, if you're able to see questions, if there are any that we need to address.
Well, I know Chung Ning and I think Drew have answered some that came in through chat, but if anybody wants to raise their hand or I hope you can raise your hand. I think I have to like click and unmute you, but if anybody has any questions you'd like to share, that would be great.
And I'm just looking back at some of the answered questions, and maybe I'll just throw in some additional comments. I see someone who asked, you know, as a Mexican that just graduated, is it better to try TN instead of H1B? I know Drew said you can do post OPT. That's great. I would recommend still trying H1B, especially if your employer will sponsor it because of the benefits we discussed with the H1B. So having that flexibility for permanent residency is really beneficial. And given the fact that it could take a couple of tries, I would recommend having an employer register you for the lottery, even if you might qualify for a TN. And then I think there was a question about, does working for the state avail the same H-1B offers as it would be with ASU? So I am not sure, you know, what it would mean to work for the state, but ASU as a public institution doesn't have to be subject to the lottery. So that's a benefit. I'm not sure, you know, what position or things someone is looking at in terms of working for the state, but I don't think, yeah, I don't know for sure if that would mean you wouldn't be subject to the cap or not. So you probably need to check with your employer to see if you would be subject to the lottery or not. Saw another question of going from NIW to EB1. So yeah, you can have multiple paths to permanent residency going at the same time. So, you know, EB1, though, most of those categories are employer sponsored. So you might be able to self-petition an NIW, but then if you want an EB1, you'd have to have an employer be willing to sponsor that as well. If you're from a country that has those longer wait times, like Indian or Chinese born, it could be really beneficial to do that, start with NIW and then get to EB1 later. If you're from somewhere where there's not as much of a wait, perhaps with just an NIW, it might be, almost as fast if you get that approved as it would be to try to, go EB1 down the road. Let's see, difference between EB1 and O1. So Chunming was right that EB1 is a path to permanent residency, whereas O1 is a non-immigrant visa. So that's correct. So EB1 provides work authorization. Sorry, O1 provides work authorization. EB1s and I-140s do not provide work authorization. So if all you had was an I-140 approval notice, that does not allow you to work for an employer. You need that non-immigrant visa like H1, O1, L1 in order to work in the US. In terms though of requirements and collecting evidence and preparing a petition, the EB1A and B is very similar. It's a very similar standard to the O1.
Jenna, I do see one, now I've kind of lost it.
Oh.
They were asking about changing from J1 to H1B.
Okay.
How can I transfer my J1 to H1B before application of EB1?
So that is, it depends if you are subject to the 2-year home residency requirement. If you are, then you can't just obtain an H-1B. You have to either spend 2 years in your home country or get a waiver. So that would be key to understand if you are or are not subject to the 2-year home residency requirement.
Just to follow that, if you are subject, you can't qualify for H or any legal permanent resident process. So you'd need to look into getting a waiver or fulfilling it.
Yeah, that's right. I see one about permanent residency. Is it only available if you have H-1B? No. You can do the permanent residency process from almost any status. You could even try to do it from outside the US and do consular processing. Most employers prefer that you have that H-1B because of the dual intent and the ability to continue to extend the work authorization. But it is not a legal requirement that you are in H-1B before you become a permanent resident.
See another one that you kind of answered in the text, but when is it the earliest possible time to try for the H-1B lottery? Do you need to be accepted by the employer to start the process, or can the application commence as I undergo my assessment before I'm employed?
Yeah. So the lottery and the process is once a year. So there are very specific timeframes. USCIS changes them every year. So I can give you kind of a best estimate based on the past years, but the registration window to include someone in the lottery generally opens up in February, and it is open for 2 weeks. So you must have an employer register you in the lottery. You can't just submit a registration for yourself without a job offer. So the employer must do the registration. And so if it's up to the employer, most of our employers that we work with do not require that you are actually employed with the company to register you. So again, if you maybe make an offer, or someone makes you an offer in January or maybe beginning of February for you to start in May or June after you graduate, they could include you in the lottery registration, between February and March. So you don't have to be working for the employer to be included, but it does have to be the employer choosing to register you.
Great. We have another one. What if it is a hospital facility, or I guess like a state government? Does the H-1B also go through the lottery?
Yeah, so cap exempt institutions are research institutions, public universities, nonprofits doing research. So it's not just about the entity themselves necessarily, but the work that they're doing. So without knowing the organization and their background, I wouldn't be able to advise. But I'm guessing, that it would probably be cap exempt and not have to go through the lottery, but I would need to know more about the specific organization.
Yeah, that's hard to answer without knowing specifically, but I have heard other universities when they have if they have a medical facility attached to them, like through their medical program, sometimes the H1Bs are done through the university. Sort of like U of A has a med school and they have a hospital attached. So if they hire staff or a doctor that's on H1B, it would be cap exempt, but that's still through the university. But state agencies, I don't really know.
Yeah.
Yeah, Banner Health, I think we have no idea. My guess would be it would be a lottery, but I don't know.
I agree.
Any other questions? Sounds good. Well, Jenna, thank you so much for all of this information and answering all the questions. We really appreciate it. I know there's a lot of anticipation for graduation and work out there, so thank you very much.
Yeah, thank you all. Bye.
Bye.